Welcome. My name is Jakub Michalak, and together with my learned colleagues Rubia Raja and Irma Muchovic, we are going to present on pre-contractual liability under the German law. Firstly, I'm going to provide you with a brief introduction to the topic. I'm going to explain what culpa in contrahendo actually is, and briefly explain when were the rules implemented in the German national system. Secondly, my learned colleague Rubia is going to discuss the pre-contractual liability under German law in detail by the virtue of analyzing the provisions that were introduced in 2002 by the German legislator. And lastly, my learned colleague Irma is going to compare the German legal system with the one in France and the United Kingdom. Starting with the definition of culpa in contrahendo, it is a Latin expression which stands for fault in conclusion of a contract. It is a very important concept in contract law for many civil law countries, which recognizes a clear duty to negotiate with care and not to lead the negotiating partner to act to his detriment before a firm contract is actually concluded. Looking at the German law, the German BGB, so the German Civil Code, Bürgerliches Gesetzbuch, did not recognize the culpa in contrahendo when it was first drafted in 1900. However, after the reform in 2002, the Schuldrechtsreform, this changed with the introduction of few provisions, namely paragraph 311 subsection 2, in conjunction with paragraph 280 subsection 1, and paragraph 241 subsection 2. These provisions mainly deal with contracts which are already concluded and turned out to be void due to a breach of an obligation prior to the conclusion of the contract.
Evaluating on the articles mentioned by my colleague Jakub, it is of importance to say that Article 281 of the BGB deals with damages for breach of duty. Article 241 Paragraph 2, subsection 2, of the BGB deals with duties arising from an obligation, and Article 311.2 and 311.3 of the BGB deal with obligations created by legal transaction and obligations similar to legal transactions. And it follows from this that parties are already bound by an obligation towards the other party by the commencement of contract negotiations, but it cannot hinder their freedom of contract. And this is also known as Grundsatz der Vertragsabschlussfreiheit, just a German word. And furthermore, the reliance on entering into a contract without there being an offer or contract to make a contract is only possible if the other party is in bad faith. And this is known as culpa in contrahendo. And culpa in contrahendo is very important because there's no possibility to charge a person in tort for bad faith or broken off negotiations. Tort law usually does not cover pure economic loss. One example for this is the licensing agreement case, where it was established that culpa in contrahendo was present because one party misled the other to believe that the conclusion of the contract was certain. Furthermore, the misled party incurred expenses in the run up to the conclusion of the contract, and the other party broke off negotiations without good reasons.
Eventually, we decided to compare the articles listed in CESL, which is the Common European Sales Law, and compare them with the actual German provisions on the following matters: freedom of contract, good faith, and interpretation. With regards to freedom of contract, Article 1 of the CESL provides that parties are free to choose the content of the contract, subject to applicable mandatory provisions. And secondly, that parties are also free to exclude the CESL, unless otherwise stated.
In Germany, there's no specific article. However, the freedom of contract can be found in doctrine. And furthermore, in BGH judgments, so Bundesgerichtshof judgments, accepted this as a norm, which is partly also reflected in Article 311, where it is stated that the contractual relation is either governed by the BGB or by the rules within the contract as such.
Secondly, regarding good faith, Article 2 of the CESL provides that both parties are obliged to act with good faith. If they do not do so, they are precluded from the use of any other defense or remedy against the other party they otherwise would have had. The party breaching the principle might further be liable for the respective violation, and eventually, that good faith principle cannot be excluded from the contract.
Under German law, we have Article 242, which prescribes the so-called treuen Glauben, and this likewise obliges the party to act in good faith. And furthermore, we have Article 826, which provides for a claim in damages in case of violation of the principle sittenwidriges Handeln, which is basically good faith. And the principle of good faith is largely developed by the BGH, as already said, that's the Bundesgerichtshof, which also holds that it is not possible to deviate from the rule.
With regards to interpretation, our last element, the CESL only deals with the interpretation of the CESL as such, which can be seen in Article 4. So there is no indication for contract interpretation in the introductory part itself.
Yes, and for German law, we have Article 157 of the BGB, which says that the contract must be interpreted according to good faith, and also Article 305C of the BGB, which states that doubts and ambiguities in the general terms and conditions will be interpreted against the benefit of the drafter, which is also known as contra preferentum.
Yes.
Lastly, I will compare the system in the UK and the French system to the German one. Whereas the UK focuses on the principle of contractual freedom and does not provide many exceptions for pre-contractual liability, Germany and France include the doctrines of good faith and fair dealing. When it comes to freedom of contract, the French system has not expressly laid down an article either. Everything that's not forbidden is allowed, as long as it's not contrary to the ordre public. This can be retrieved from Article 4 of the constitutional text of the Déclaration des droits de l'homme. The UK has the same approach as in France and Germany. However, it is limited by several doctrines of undue influence and misrepresentation, for example. When looking at the good faith principle, in France, Article 1134 of the Code Civil expressly provides for good faith. In the UK, good faith is not recognized as a general doctrine. However, in the past it could be seen that the good faith provisions were introduced for specific contractual relations. When it comes to the interpretation, in France, Article 1156 and 1164 of the Code Civil are of importance. It is stated that the common intention of both parties is of importance, and that ambiguous clauses must be interpreted as serving the purpose of the contract. The UK adheres to an objective reasonable person test, according to the situation of the contracting parties. It must be noticed that the development towards the objective standard test took place in the 1970s. Before that, there was a more literal approach.